you have, Michelle, if you've got your phone with you, can you turn it completely off?
Yes, let me actually.
All right. The Honorable Chief Justice and Associate Justices of the Supreme Court of North Carolina. Oh yes, oh yes, oh yes, the Supreme Court of North Carolina has resumed sitting for the dispatch of business. God save the state and this honorable court.
Good morning. Our next case is State versus Gordon, and we will hear from the appellant.
May it please the court. Once again, Your Honors, my name is Joe Finarelli, here for the Department of Justice and the state in this appeal. I'd like to reserve 5 minutes for rebuttal. The majority below erred because it concluded that the majority below erred in light, especially in light of this court's recent decision in Strudwick, holding that it was not unreasonable to assess the constitutionality of a search today for the search that will actually be conducted when Mr. Gordon leaves prison in, I believe it's 2032. Mr. Gordon was convicted in 2017 of 5 different charges. He pled guilty to second-degree rape, statutory rape, taking indecent liberties with a child, first-degree kidnapping, and assault by strangulation. At the time of his plea hearing, the uncontested factual basis was that he locked the bedroom door of the 15-year-old daughter of his live-in girlfriend. He choked her until she lost consciousness, and she woke up naked on the floor with him on top of her. He bit her back, her breasts, and her forehead, forced his penis into her vagina, and choked her again. The assault was stopped only when the victim's mother, sleeping in the apartment, had awoken, heard muffled screams, went to investigate, and broke down the door of the locked bedroom. And when she did so, she found the defendant on top of the victim, penetrating her vaginally. At the time of the offense, there were 4 other siblings in the apartment, one of whom was the daughter of the, I think, 1 or 2 year old toddler of the defendant and the live-in girlfriend. The defendant pled guilty. He was sentenced to 190 to 288 months, and based on the Department of Public Safety's website last night, he's due to be released on December 1st of 2032. At the SBM hearing that was conducted after or at the time of sentencing, there was similar testimony to what I think this court has heard in other cases and has considered in other appeals. The probation and parole officer testified about the dimensions of the device, its physical characteristics, that it's water resistant, it doesn't interfere with physical labor or the individual's work, that it requires 2 hours a day of charging, and that it tracks the location of the offender and provides the minute-by-minute position and the speed with which the offender moves from one location to the next. The probation officer also testified that SBM can both inculpate and exculpate offenders in subsequent criminal investigations. And she testified that defendant received a score of 3, which is a moderate low on the static 99 risk assessment. At the time of the issuance of the SBM order, the trial court considered 4 facts that it considered important in the reasonable analysis. 1, the defendant had a prior assaultive history of violence against women. I think he had 2 habitual assault convictions, which I think included 2 predicate offenses for each. The court was also persuaded by the circumstances of the criminal offense here, that there were other children present in the apartment at the time. And the court also identified what it called a relatively minor physical intrusion to wear the device, pointing out specifically its water resistance and the fact that it's charged 2 hours per day. And the court also noted that Mr. Gordon could apply for removal from the satellite-based monitoring requirement through the probation, post-release supervision, and parole commission in accordance with the statutes that existed at the time. I think it's important to begin with the impact of the Strudwick opinion. This court, 2 weeks ago, I think now, issued the Strudwick opinion, concluding that it was appropriate and constitutional to assess the search under the circumstances present today, even though the search will not be conducted for Mr. Strudwick. I think it was 20 or 30 years, and far longer into the future than the search will be for Mr. Gordon. It rejected a facial challenge then to the satellite-based monitoring statutes, and then discussed the as-applied aspects of it with respect to Mr. Strudwick. I think there's one aspect here, and I know that defendant has said they are bringing an as-applied challenge to the court. I would note that to the extent they would ask here, like they did at the Court of Appeals when we did supplemental briefing after Grady, defendant asked for a broader application of the unconstitutionality and asked that it be applied to all aggravated offenders, regardless of if they were currently incarcerated and would be released in the future where the search were to be conducted. And I think Strudwick forecloses that possibility, and I think it does so definitively. With respect to the remainder of the Strudwick opinion, again, I think the framework that the court follows, if it follows what it has done recently in Hilton and Strudwick, I think gets us to the same conclusion that as applied to Mr. Gordon, the findings of fact from the trial court, which again are undisputed, support the constitutionality of or the reasonableness of the search of Mr. Gordon when he is released from prison. And he will serve 5 years of post-release supervision. And in addition, I know this had come up during the argument earlier this morning, the statute that the legislature has enacted to take effect December 1 does directly impact Mr. Gordon. He has a lifetime monitoring order. He will be he will be able to exercise the statutory right of judicial review to reduce that lifetime order to 10 years. He will be able to do so. In addition, there's the remedy of Rule 60, were that necessary, although it would appear from the way the statute's written that it's determinative. If he has a lifetime order, it has to be reduced to 10 years. And if he's already been on it for 10 years, which, of course, at the time he won't, at the time he's released, he won't, it has to stop at that 10-year mark. So, but I think the framework that the court discussed in Strudwick with respect to this particular circumstance applies here. And if you apply that same framework, I believe you get to the same result that the satellite-based monitoring order for Mr. Gordon, is equally constitutional. In Hilton, which preceded Strudwick and upon which Strudwick was based for the discussion of the aggravated offender standard, the court discussed the state's interest in protecting the public from sex offenders is paramount. The purpose is to protect the public from sex offenders. SBM assists law enforcement in solving crimes and deterring recidivism. That based on California empirical studies, which it points out the legislature has relied upon in its own new upcoming enactment, shows that SBM is effective in reducing recidivism, and that privacy rights were severely diminished while on post-release supervision, and which, again, Mr. Gordon will be at the time he's released, and that they're diminished thereafter, less so than the severely diminished status during post-release supervision, but diminished all the same by virtue of the sex offender registry status and obligation. Strudwick, again, building on what had been decided in Hilton, highlighted that the evidence there that the SBM only tracks the offender's location, not what they're doing there. Similar testimony was provided by the probation and parole officer here on page 46 of the transcript. The trial court in Strudwick found that the SBM device was a relatively small and unobtrusive one. The trial court here made similar findings that it was a relatively minor physical intrusion, in the words of the trial court. The defendant in Strudwick did not challenge any findings of fact. Mr. Gordon challenges no specific findings of fact here, i.e. that they're not unsupported by the evidence. Clearly, he challenges the sufficiency of those facts to justify the imposition of the search through the lifetime enrollment order. The totality of the circumstances discussion and from the case law, as the court is well now aware, it requires the balancing of the intrusiveness of the search against the promotion of the legitimate governmental interests. Here, as I've discussed, the circumstances, the intrusiveness of the search has been addressed by the court fairly definitively with respect to aggravated offenders in Strudwick and in Hilton. The promotion of the legitimate governmental interests. The court also discussed the deterrent effect of SBM, or the deterrent purpose of SBM, and the deterrent and the purpose of solving and preventing crime. None of those, I think, bear extra repetition here, as the court is familiar with its rulings and its analysis on those points. Given the factual basis, the fact that Mr. Gordon, as well as an aggravated offender, the circumstances of his offense, and the concerns addressed by the court in Strudwick that the new statute will limit the term of SBM enrollment to 10 years, is an appropriate framework to conclude similarly here with respect to Mr. Gordon. I hesitate to stop at 17 minutes, but hearing no questions from the court, and I know
You don't get extra credit for using all your time.
I know, and I know we just discussed these issues at length just an hour ago, so I will reserve any remaining time for rebuttal, and I promise I will not use all 17 minutes at that point. Thank you.
Thank you, counsel. We'll hear from the appellee.
May it please the court, counsel. My name is Michelle Goldman. I'm an assistant appellate defender representing Mr. Gordon in this appeal. This case raises the issue of whether the state can track Mr. Gordon for the rest of his life after his release from prison, monitor his every movement, and conduct a daily warrantless search of his home, despite the testimony from the state's only witness that Mr. Gordon was not likely to reoffend. Because Mr. Gordon does not present the level of risk this court used to justify SBM searches in Hilton and Strudwick, the answer must be no. I intend to briefly discuss applicable Fourth Amendment principles. Then I will address how the rationale this court used to uphold SBM against a facial challenge in Hilton and Strudwick mandates the conclusion that in this as-applied challenge, under the unique facts of Mr. Gordon's case, the SBM order here is unconstitutional. Turning first to the Fourth Amendment principles at play, it's beyond dispute that SBM affects a Fourth Amendment search. The U.S. Supreme Court told us that. To be constitutional, that SBM search has to be reasonable. To be reasonable, there must be a legitimate government interest that outweighs the intrusions on Mr. Gordon's privacy interests. When a statute like SBM authorizes a search, it can be challenged on its face or as applied. In Grady III and Hilton, this court looked at the facial constitutionality of SBM statutes as the SBM statute as it is applied generally to different categories of offenders subject to its terms. In conducting its targeted facial analysis, this court applied a presumption of constitutionality to the statute and placed the burden on the challengers to demonstrate its unconstitutionality in every circumstance. This case is different. Mr. Gordon raised an as-applied challenge to his SBM search. This court must look at the constitutionality of the order under the circumstances of this particular case, and the state bears the burden of showing reasonableness. Before I get to that balancing test here, it's important to look at what this court said in Hilton's facial analysis of the constitutionality of the SBM statute as it relates to aggravated offenders. In Hilton, the court identified the legitimate government interest at issue as protecting the public from sex offenders. Hilton said that SBM serves this legitimate governmental interest in three ways. First, and most importantly, Hilton presumed the high risk of reoffense that sex offenders are presumed to pose to the public. Then Hilton said that SBM would help police solve recidivist crimes committed by people on SBM. And finally, Hilton said that SBM would be an effective way of deterring reoffense. And those were Hilton's justifications for upholding, this court's justifications in Hilton for upholding the SBM statute against a facial challenge. As discussed in Hilton, SBM's justification rests in large part on the assumption that sex offenders present a high risk of reoffense. And the statute supports that focus of the SBM's purpose. Under the SBM statute, there's the statement of purpose that focuses on protecting the public from sex offenders' perceived high risk of reoffense. Under the current version of the statute, the legislature tied removal from SBM with a showing that the person is not likely to pose a threat to the safety of others. And finally, under the amended statute, the legislature tied the imposition of SBM in the first instance, in the first place during the SBM hearing, to an individual finding based on a DAC risk assessment that the person, quote, requires the highest possible level of supervision and monitoring. So it's clear from Hilton and the statute that SBM was designed to apply to offenders presenting a high risk of recidivism. An offender like Mr. Gordon, who is not likely to reoffend, falls outside the statute's purpose. On this point, this case is like Britt versus State, which Mr. Grant discussed with this court a short time previously. There, Mr. Britt was challenging the felon in possession of a firearm statute as violating his constitutional right to bear arms. He challenged it both as applied and facially. The Court of Appeals upheld the statute as against the facial challenge, and this court was then tasked with assessing whether, as applied to Mr. Britt, his constitutional right to bear arms was violated by the statute. And this court said it was. This court said that the purpose of the felon in possession of a firearm statute, which was to protect the public from a perceived danger posed by felons possessing firearms, was not served by preventing Mr. Britt from possessing a firearm. It said that Mr. Britt was insufficiently dangerous to justify prohibiting him from possessing a firearm, and his constitutional rights were thereby violated. Just as in Britt, the SBM statute cannot constitutionally be applied to Mr. Gordon because he does not present the level of risk this court required in Hilton and in Strudwick to uphold the facial validity of the SBM statute.
Ms. Goldman, when the hearing was held in this case, the trial court didn't have the benefit of this court's opinions in Hilton and Strudwick, correct?
That is correct.
So would it make sense to remand for the trial court to assess whether the defendant here falls outside the statute's purpose?
I think that the court could certainly do that. That would be an available option. I do think that looking at the evidence that the state put forth, and the state was aware at that point that it was its burden to show the reasonableness of the search that it sought, the evidence that it presented could not possibly justify or support a constitutional search in Mr. Gordon's case. However, it's certainly within this court's authority to remand it for that purpose. And I would just say that the other interests identified in Hilton and Strudwick, that the helping law enforcement solve crimes and deterring future sex offenses by recidivists, don't apply here for a couple of reasons. First of all, Mr. Gordon is not likely to reoffend, so the interest in solving crimes he's not likely to commit or deterring him from committing crimes he's not likely to commit makes no sense, and that interest is not furthered by imposing SBM for life on Mr. Gordon. And further, as with Mr. Griffin, Mr. Gordon's crime was against a known person in his home, and the interests identified by this court in Hilton and Strudwick simply aren't served here.
Would Strudwick apply here as to the temporality of this situation involving the defendant, your client?
Yes, Your Honor. I believe that and I'm not up here arguing to the court that the timing of the order renders it unconstitutional based on this court's ruling in State versus Strudwick. I think that court has definitively answered that question, and so I'm just focusing on the as-applied challenge that Mr. Gordon has always made, and I do think that Strudwick is very important to this case because in Strudwick, this court was careful to reiterate that a defendant who is potentially subject to SBM has a right to a hearing at which the trial court must assess for that individual whether or not SBM will be a constitutional, reasonable search in that person's case. And that's what Mr. Gordon is asking this court to look at, whether for him, during his individual SBM hearing, the state met its burden, as this court recognized in Strudwick was its burden, to show that this search is constitutional. And Mr. Gordon's position is the state didn't meet that burden because Mr. Gordon was not the type of offender, he did not present the level of risk that the statute is designed to address. It's clear as I mentioned, under both Hilton and the statute, the current statute and the amended statute, that the focus of this law is on high-risk offenders, and Mr. Gordon is not one of those.
And you're making that assessment based on the static 99 score?
I am making that assessment based on the totality of evidence the state presented at Mr. Gordon's SBM hearing, which
He had 3 prior assaults on a female.
the court was looking at whether or not he would be likely to reoffend in a sexual way. This, to my knowledge, no case has said that SBM's purpose is to prevent any further criminal activity. But
He also had an assault on a child under 12.
that's correct, Your Honor. And I will.
So, I mean, what I think I'm hearing you say is you've got to look at the precise facts and circumstances of this one sexual assault, and the trial court can't go beyond that in trying to anticipate, and it's very difficult, but trying to anticipate the risk that this individual shows to society based on the 5 sexual assaults that he committed.
I think that those other assaults that the court is referring to were considered and went into, and he received points for those in the static 99 risk assessment that the state relied on. And it's interesting that our legislature, in its amendment of the statute, has tied the appropriateness of SBM to the very risk assessment that the state used in this case that showed that Mr. Gordon was unlikely to reoffend. And additionally, I would say it wasn't just the static 99. The state's witness testified that Mr. Gordon was unlikely to reoffend, and when asked whether he had any information about other reasons why Mr. Gordon should be subjected to SBM, he said he did not. And that was at page 62 of the transcript. I wanted to turn quickly to the privacy interests, which are the other side of the balancing test in this case. This court has recognized that SBM intrudes in a variety of ways by attaching a monitor to the person, to Mr. Gordon's ankle in this case, and tracking his every movement, every moment of every day, and requiring him to remain tethered to a wall outlet for 2 hours a day, and allowing the state to enter his home every 90 days to check the equipment. But there is one significant intrusion that was not mentioned or addressed in Hilton, Strudwick, or even Grady 3, and that is that SBM effects a daily warrantless search of Mr. Gordon's home. In United States versus Caro, the Supreme Court held that the government's monitoring of a location tracking device in a can of ether located in a home constituted a search of that home, just as surely as if a DEA agent had entered the home to check to see if the can was there. That means that every time Mr. Gordon goes home with the SBM device attached to his ankle, the government is conducting a warrantless search of his home. In Caro, the Supreme Court was unpersuaded by the state's argument that because it was just obtaining location information, the Fourth Amendment was not offended. Similarly, in State versus Elder, this court refused to apply the special needs exception to a warrantless search of a home for guns that was authorized in a 50B domestic violence protection order. The Elder court said that a 50B defendant's fundamental right to privacy in his home outweighed the state's vital interest in protecting victims of domestic violence because the person's home was protected by the highest constitutional threshold. Having identified a limited state's interest in this case because of the lower risk, or the fact that Mr. Gordon is not likely to reoffend, and the heightened issues raised by the daily search of his home and the other intrusions on Mr. Gordon's privacy interests that this court has already addressed, the balancing in this case, on these specific facts, tips in Mr. Gordon's favor. And I did want to briefly respond to a question Justice Morgan asked in the argument before regarding the reduced privacy interests of a sex offender, even following post-release supervision. While I share my colleagues' views that the privacy interests are not grossly reduced following a period of post-release supervision, even assuming that they are, no court has said that they are non-existent. In Hilton and in Strudwick, there was an assumption that sex offenders following post-release supervision did have privacy interests. And so if those interests exist, and the state's interest in monitoring somebody using SBM is incredibly low, like it is with Mr. Gordon, and the intrusions are even higher than were discussed in those other cases because of this warrantless search of the home, as applied to Mr. Gordon, the SBM search for life in his case is unconstitutional.
So, Ms. Goldman, is the issue about the search of the home different here than in the other cases, or is it just being raised here?
It's being raised here, Your Honor. I think the way that in Strudwick recognized that there was a search of the home, but as the cases before it, it was referring to and looking at the 90-day equipment check that the statute allows. I don't think any court that I've seen, or our courts, have looked at this home search that occurs on a daily basis. If you look at the Caro decision, it's quite clear that that's what's happening, and that's a much larger intrusion. As we all know, the sanctity of the home is paramount under the Fourth Amendment. In deciding this case, it is imperative to remember that the Fourth Amendment serves as a shield for all of us against an overly intrusive government presence in our lives. The strength of that shield is determined by courts entrusted with applying the Fourth Amendment's requirement of reasonable searches and seizures. Faithfully adhering to the Fourth Amendment's dictates is especially challenging in cases like this one, where the person invoking the Fourth Amendment's protections is among the most reviled in our society. How this court meets that challenge in this case on these facts will either fortify or further erode our constitutional shield. Here, the state failed to show reasonableness of the search it sought. The SBM order was unconstitutional the moment it was entered, at its inception. The Court of Appeals recognized its obligation to fix the problem before it. Mr. Gordon respectfully requests this court to affirm and potentially modify, because of the temporal issue, the Court of Appeals decision. Thank you.
Thank you, counsel. Rebuttal.
Nothing from the state.
Thank you to both counsel. Madam Clerk.
Nice to meet you.
Nice to meet you.
I don't know that we've ever argued together. Usually I get Jim or Sterling. Is Sterling still there?